All right. So good morning again, everybody. Welcome to the LIBOR December legal update. My name is Patrick Fife. I am LIBOR's general counsel, and I appreciate you being here this morning. We've got a lot of information to go over, a lot of new material. For those of you that have taken this class before, you'll know that I try to put some new material in every month. And the reason I do that is because the law is always changing. I think that it's very important, given that you have a way to stay on top of those changes. I'm glad you're here in this class. I encourage everyone to try to take the class every month if you can. If you miss it, it's available on our website. But it's really important, given the work you do and the license that you hold, that you make sure you have a way, a process to stay on top of all the changes that occur. And I think LIBOR gives you some really good resources to do that. So if you don't already get our emails, please go ahead and sign up for them. We every week on Thursday, you'll get an email from LIBOR that has a lot of good information, including a legal tip that usually addresses some of the most relevant new trends, new topics, new laws, and also new issues that we see coming up frequently in the field. Also, a lot of good information about webinars, events, a way for you to get reliable information to keep you apprised of all the changes that are happening. All of that information is also on our website. It's on lirealtor.com. Access to all of the legal tips, our forms, documents on demand, our dispute resolution center, which I always like to plug at the beginning of this class. If you have any issues with another realtor, it could be you're thinking of filing an ethics complaint. It's a communication breakdown over the inability to get access to a property, whatever it might be. Call our dispute resolution center, call our professional standards department. We have an ombudsman and mediation program that for free can try to help reach a resolution before the dispute materializes into something a lot more significant, and before it becomes a ethics complaint, before it becomes a lawsuit. It's a great program. It's free to members. So if you are running into issues, please feel free to use that resource. And we also have a ton of other resources on there for you to share with your clients. Last sort of, I'll say, general tip in terms of trying to stay on top of trends or getting assistance with issues. Please remember, LIBOR has its own legal support center. We give you access to an attorney who can provide you information on real estate matters. It's available 9 to 5, Monday through Friday. Just call the main LIBOR number, which is 631-661-4800, and it's extension 335. And I can tell you, we get a lot of calls, and it also helps us because it's good for us to know the issues you're struggling with. And that's how I've been starting my class. I like to recap some of the calls that we've gotten in over the last month, because if your fellow members are struggling with an issue, it's probably something that you or somebody in your office may be having a question about as well. So let's start with some of the questions that have come in. First question is, does a buyer broker need to provide a copy of their buyer representation agreement to the listing broker or seller? This is a question that's come in a lot since the NAR settlement and the requirement that you have to have a written agreement with your buyer before touring a home. The answer is you do not need to provide a copy of that to the listing broker or seller. That's your agreement with your buyer, right? It has nothing to do with the seller. It has nothing to do with the listing broker. I equate it like if you represented the seller as the listing broker and a buyer or their agent asked you for a copy of the listing agreement, you're not going to give that to them. That's your agreement with them. That's between you and the seller. Same thing with a buyer representation agreement. It's between you and the buyer. You do not need to provide a copy of that to the listing broker or seller. So similarly, we've gotten the question from listing brokers. Well, I'm a listing broker, right? Don't I need to verify that the buyer broker has an agreement with their buyer? I need to check. I need to know. The answer is no. There's no need for you to verify what the buyer and their broker have agreed to at all. It's not relevant to the seller, right? When you represent the seller as a listing broker, your obligation is to what? Obtain the best possible offer for the seller. It doesn't matter what the buyer has agreed to with their agent. It's completely irrelevant. If the buyer and their agent have agreed to whatever compensation they've agreed to and they want to ask the seller to pay it, let them do it. It has nothing to do with the negotiation that you need to do on behalf of your seller. And your duty is not to police whether the buyer broker has an agreement with their buyer or find out how much the buyer broker is being compensated. It's not your duty. Yes, it's a rule under the MLS rules, but it's not the listing broker's obligation or responsibility to police that or find out whether an agreement exists. It is the listing broker's obligation to do what's best for their seller, and that is entertain any and all offers, and accept the best one. Get their seller's permission to accept the best one. Period. So, kind of my advice, and one of the, I think, real principles behind the NAR settlement was you stick with your side, I stick with my side. So if I represent the buyer and I have an agreement, that's between us. And if I represent the seller and I have an agreement, which you need to, it's between the seller and the listing broker, period. Another question that came up about twice in the last month is salesperson asked, well, can I have an ownership interest in my brokerage? The answer is no. Under New York law, a licensed real estate salesperson, which includes an associate real estate broker, no real estate salesperson or associate broker can own any voting shares of stock in a real estate brokerage corporation in which they are associated with, period. Also, real property law 441B says that if you have you can't be issued a salesperson license if you're an officer of the corporation, a manager, a member of any kind of real estate brokerage. So you can't have an ownership interest. You can't have an officer position, a member position in an LLC, no ownership interest, no officer position in any brokerage if you're a salesperson or associate real estate broker. That also means, and I'll cover this a little bit later, you can't advertise that you are the vice president of ABC Brokerage if you're not an owner of that brokerage, if you don't hold an ownership interest. So salespersons, associate real estate brokers, you cannot use corporate titles. And just a kind of a real word of caution here, if you're using that title and you do actually, as a salesperson, have some kind of ownership interest, you could have your license not only revoked, but revoked retroactively by Department of State, which could mean forfeiture of commissions. So be careful. Make sure that you're never advertising yourself or holding an ownership interest in your brokerage if you're a salesperson or an associate broker. Is it legal for me to say, I'm going to address some rental questions. This comes up a lot. Can I say that my office doesn't handle rentals, or that I, as an agent, don't handle rentals? Yes, it's okay to say that. And I give you a caution though. It has to be the case, right? That needs to be the way you actually handle things. So there's no legal obligation that a salesperson, a brokerage actually handle rentals, right? There's nothing that says you have to handle rentals. You may make a business decision. It's not profitable. It's too much work. It's too much effort. So our office, or I as a salesperson, say, I'm not going to deal with rentals, period. And that's fine. I give you the caution though, make sure you're consistent with your business approach. Why? It can lead to fair housing complaints if you're not. So if you only help some prospects with rentals, but not others, that can certainly lead to a claim that you refuse to handle rentals based on a protected class. We'll talk about lawful source of income later, but certainly if you only handle rentals related to somebody that has a job versus individuals that have vouchers or on Social Security, that's discrimination. So, by having an inconsistent practice of, well, it really depends on your income or it depends on some type of factor, you're setting yourself up for a fair housing complaint. So I tell people if that's your policy as an agent or an office that you don't handle rentals, make sure you stick to it and make sure that everyone in your office is aware of it and follows it consistently. Consistency is really the key when it comes to this and when it comes to fair housing. Related question. So, well, what if my office doesn't handle rentals? Maybe you're even a commercial brokerage, right? You don't handle, and I'll say rentals meaning residential rentals. So let's say there's no way 20 years you've been in business, never handled any residential rentals. You never will. Do I still need to put all these notices on my website, the state required notices, including the reasonable accommodation and modification notice? Do I need that? The answer is yes. So remember, in New York, there are three things that brokerages need to have on their website, links to the fair housing notice, the broker standard operating procedures, and the third, which has been in effect for about 3 years, is there's a required notice to prospective tenants who may need a reasonable modification or accommodation due to a disability. That notice must be on all real estate brokerage websites, or a link to that notice has to be on all real estate brokerage websites. It doesn't matter the type of brokerage you are. So even if you are a commercial brokerage or a residential brokerage that doesn't handle rentals, you need to have that notice on your website. If you've got questions about what notices need to be on your website, look at our website. There's a legal tip on that kind of walks you through all of those. Next question. This one came up twice this month, and it's always good to get a refresher. Can a landlord charge additional security for a pet? I'm kind of going to give you the lawyerly answer. It's yes, but there's always a but, right? But only if the total sum of all deposits required by the landlord does not exceed 1 month's rent. So we have a law in New York called the Tenant Protection Act. It's been in effect since 2019. And it says landlords in New York can't charge more than 1 month's security. That includes all deposits. So if a landlord, which seems to typically be the practice, already requires 1 month's rent as security, they cannot charge an additional deposit for a pet. That would violate the tenant violate that law, right? But if the landlord does already require that 1 month security, they can charge a higher rent. They can charge a pet rent. That is fine. They are allowed in that instance to charge a pet rent. So meaning like an additional rental fee. We're going to charge $50 per month more if you have a pet. That is fine. However, remember, pet rent, extra security, whatever it is, you cannot, or a landlord cannot charge that for service or emotional support animals. And why is that? If you've ever taken a class with me, number one rule, right, when it comes to service and emotional support animals, they are not pets, right? So never should a landlord demand or require, if they do have any kind of pet rent, pet security, never going to require that for service or emotional support animals because they are not pets. They're effectively tools that aid somebody in overcoming a disability. They're considered a reasonable accommodation. Last question, just to go over, is what is the FAIR Act and where does it apply? So New York City has something called the Fairness in Apartment Rental Expenses Act, the FAIR Act. And that is the law that prohibits residential landlords from passing the fee of their brokers on to prospective tenants. So in New York City, and this is a law that applies only to residential apartments in New York City. So that's the 5 boroughs. It does include Queens, which is part of our jurisdiction here in LIBOR, but it does not include Nassau and Suffolk counties. So we've still gotten calls. This law went into effect in June. We probably get 5, 6, 7 calls a month about this. But it prohibits any apartment, that's located in New York City. And in those cases, the landlord cannot pass their broker fee on to the tenant. So landlord cannot say to the tenant, you owe me, the security, first month's rent, and my broker fee. That is not permitted for any residential rental in New York City. All right. I see some questions on some of these other topics. I'm going to have to get to them at the end, just because I want to move forward. So we'll go through the FAIR Act, and also I know there's some questions about emotional support animals. But I want to get on to a couple other topics. And the first one is just a major warning on cold calling. You've probably heard this mentioned before, but there is a law in New York, and you probably heard it throughout COVID, that says it's a New York law, prohibits unsolicited telemarketing sales calls to any member of the public during a declared state of emergency. This isn't just applied to real estate licensees. It applies to anyone offering goods or services in New York. You're offering services, so real estate licensees are covered by this. And you're probably like, well, Patrick, that's no longer in effect. COVID, the states of emergency are all over. Yes, that's right. But believe it or not, we are under right now 2 states of emergency, statewide declared states of emergency in New York. And they're both going to go at least right now through late December. And these may be extended. They have been extended. You can see the first one, which relates to public order at correctional facilities. It was declared originally at the beginning of February. It's been extended 12 times now. So this is something we're kind of lived under. You may not feel it. I know I don't, but we've lived under sort of a perpetual state of emergency in New York for the past several years. So that means, based on the law, and I know a lot of people are going to scream, this law is not fair. It's not a good law. I agree with you wholeheartedly. I'm just the messenger. But it means that you can't make unsolicited phone calls or text messages to members of the public, right? All other marketing, fine. Door-to-door, email, social media, no issue with that, right? And you're like, well, Patrick, no one enforces this. There's people that call me all day on my phone, and I get them too. The latest one is somebody wants to make me, I think, a $40,000 loan, pretty much 5 times a day. Yes, we get cold calls, but those people don't hold a license that's regulated by the Department of State. We've been kind of informed that Department of State has been enforcing this law as well as other telemarketing laws. Department of State has a number of divisions. We primarily deal with the division of licensing when it comes to real estate licensees. They do have a division of consumer protection. That division of consumer protection has been making complaints based on consumer outreach against some real estate licensees. And the fines for violations of this law can be $20,000 per call. And Department of State can seek to impose strict liability and seek to hold brokers liable for calls made by their salespersons. And this is why I'm giving you the warning. There is one documented instance that we were aware of where Department of State was seeking to hold a licensee and the brokerage and the owners liable for over $13 million in connection with over 250 allegedly improper cold calls that were made during states of emergency, that were made without, in violation of the do not call list. So the state is looking at this, and if they get complaints, they will investigate. So I just want you to be careful. This is not a law that is just ignored entirely. So you could be putting yourself at significant risk if you make cold calls during a state of emergency. In addition, just so everybody's aware, there are new rules that went into effect earlier this year for making cold calls. New laws in New York, that once cold calls are allowed, and we're no longer under a state of emergency, there are very specific rules that you need to follow if you're going to make a cold call. And if you don't, you could again be fined up to $20,000 per call. And people do report these cold call violations. I will tell you, based on kind of just general research I've done, consumers don't really like cold calls, and they do make reports. They do make reports to the Federal Trade Commission. Department of State has access to that database. So if they get a complaint, they can investigate the Federal Trade Commission database of reported calls. So it's just really important that you make sure that even once cold calls are allowed, you're following all of the proper rules. I see a question from Mariska about where can you look at state of emergency. So if you look at the governor's website, actually has a page. It's not really formatted that well, but lists all of the states of emergencies that have been issued, or executive orders, I'm sorry, that have been issued. Within those executive orders are states of emergency. However, NYSAR, our New York State Association of Realtors, also has been maintaining a page that updates things. And I will tell you that NYSAR and LIBOR, once there is no longer any active states of emergency, or the law changes, there's been a lot of efforts to try to get this law changed, we will let everyone know. So, until you kind of further notice, I think it's safe to presume we are still under a state of emergency and cold calls aren't allowed. I just bring this up to your attention to remember that you also have to comply with the do not call registry. So you can't make calls to individuals who are registered with the do not call registry. So you need to make sure that once cold calls are allowed, you're not violating state law, you're not violating federal law. And I just want to reiterate, I get the frustration that others make cold calls. Well, the guy or woman who's selling you solar panels, right, or car warranties, they don't hold a license from New York State. You do. And because of that, I think you're expected to be held to a higher standard, and Department of State is going to enforce the law. So bottom line, just be very careful when it comes to cold calls. If you're a brokerage, I encourage you to make sure you have some policies in place that you inform everyone in your office, so that if somebody goes rogue, you could at least point back and say, hey, that wasn't with my permission. I had a policy that said during states of emergency, no cold calling. And here's also the script we give our salespersons for cold calling once they are allowed. So really just be careful with it. Weigh the risk, I think, really outweighs the reward when it comes to cold calling. All right. Another topic I really want to hit on, and you've probably heard, and you're going to tell me, Patrick, I know everything about AI. Like, this is a bored and tired subject. Everybody talks about it. Not everyone talks about the risks. And also there's been a recent alert from Department of State about AI that came out just a few weeks ago. So I think it's really good to go over it. And something that everybody needs to be aware of, because if it's on Department of State's radar, that means they're, one, getting inquiries or complaints, and two, it is something that they may look at when it comes to your license. And at the end of the day, you need to keep your license. Without that, right, you can't make any money. So it's really important to listen up on this one. Obviously, we all know what AI can do. You can create listing descriptions. It can help with property searches. It can help with marketing, social media, enhancing your visual content. I'm amazed. I see things my kids can do with it. It's really impressive what can be done. And so it's certainly something that everybody should be looking at and trying to find ways to create efficiencies in their business. But there are risks, right? Certainly not 100% accurate. There's already been a couple cases brought against attorneys who have tried to use AI to write legal briefs. Didn't go too well. A lot of inaccurate information, cases that were made up, quotes that were not accurate. So really, even with the advances that have been made, it's not accurate. I've just played around with things like at home to try to kind of get a sense. My wife wants to kind of redecorate a room, and you put things in there about how to rearrange the room and how different furniture would look, and you know, it puts the thing in the wrong place. It removes a wall. It's not always accurate, right? Doesn't always comply with fair housing laws. So if you're going to use it to write a property description, you got to read that description. It may put things in there like great for families. That's a no-no, right? There's other things. People have been using it for screening. Landlords also potentially create problems. The chat bots that communicate, got to be careful what they're saying, right? A lot of testing needs to be done with it. The output has to comply with advertising laws. And that's like the main thing I want to hit on here, right? You have ethical responsibilities about being honest and truthful. You can't exaggerate, misrepresent, or conceal material defects when it comes to a property or the material condition of a property. So again, be careful because AI doesn't always get things right. Like I mentioned about kind of redesigning the furniture in our family room. I've got one wall on the right side when you're looking at where the TV is, that's like an open wall. When my wife was playing around with AI and trying to redesign the room, all of a sudden it closed that wall and had a TV on it. And that wasn't the request that was put in. It makes mistakes. And if you're not really careful about what you're looking at when you're enhancing images, you might remove a wall, a window, something that's an important feature. You have to be careful. It can be a real big problem with photos, put you in violation of the code of ethics, and also with New York state law. So, Department of State doesn't have any formal policy on AI use. Well, I just want to make that clear. There's nothing I could point to you and say, all right, read this. This is what state law is regarding the use of artificial intelligence. There isn't anything, but a couple laws that we have in New York, certainly dishonest and misleading advertising prohibited. That can subject you to disciplinary action. And also New York regulations say all advertisements have to include honest and accurate depiction of the property being sold or leased. Also have general business law, which applies to other businesses as well as real estate licensees that prohibit deceptive acts, false advertising. So there are hooks that the state can use to say, hey, your artificial intelligence created a false or misleading representation of a property. Therefore, you're subject to penalties, fines, and potential license suspension or revocation. So I'm bringing this all up because just this past month, Department of State, you may have received it. They issued an alert on the use of AI in real estate. Department of State issues alerts maybe once or twice a year. So obviously, this is something that's got to be pretty heavy on their mind. The warning was issued to home buyers and also you, real estate professionals, about the rise of AI and the risks. And you know, they're aware that the trend is being used to enhance property, enhance marketing of property. But they said it, quote, also raises important concerns about accuracy, authenticity, and the potential for false advertising. Just a little bit more from the warning, and this came directly from the Secretary of State, that, you know, while AI can help home buyers imagine what a potential home can look like, these automated technology tools may produce misleading or exaggerated representation of properties. And this is the quote at the bottom that I just want everybody to focus on. This is again from the Secretary of State of New York saying, I urge real estate agents to be mindful when listing and consumers to be vigilant when searching for their dream home. So I thought this was another interesting point that Department of State made. Does the use of AI images actually help? I think most of us think, yeah, it does. The alert from Department of State actually warned that it may not. It could actually negatively impact your bottom line. And I will be honest on this one. I have not read this study. I just kind of I just became aware of the DOS alert within the last 2 weeks or so. So I haven't had a chance to dig any deeper, but they cite a study from something called the International Journal of Information Management that found that consumers distrust AI-generated images and perceive them as less authentic, less professional, and misleading, which negatively affects consumer trust and purchase intentions, particularly for high-involvement decisions like buying a home. So, we talk about risk reward so there's certainly a risk that we've really gone over with the use of AI, but is there really a reward when it comes to alteration of images? I think it's something you really need to think about. Another warning from Department of State is AI is being used to impersonate you. So I've learned that the warning that the Department of State issued actually was stemmed from they had received reports about listings that were on the internet where purported licensees were seeking money particularly for rentals. And then once they got whatever it was, deposits, things like that, they just disappeared. So the consumer made a complaint. DOS reached out to the person who they believed was the agent, and it turned out it was a deep fake. It was somebody who used AI to impersonate a real estate professional, and really in many different respects. They're using AI to impersonate you, put fake listings out, and trying to scam prospective tenants. So what can you do to stop that? Well, I think you need to just get into practice, and I know it's tedious, but search your own profile, search your identity, just search your listings, put a note in your calendar, once every 2 weeks, you're just going to search your name. It's a little bit of extra work, but protects you. The other thing that I want to encourage all of you to do is you should use tools like multi-factor authentication to prevent scammers from accessing things like your MLS access or any other important tools that you use. It's one thing for somebody to put a fake or misleading fake listing out on some kind of third-party website. But we've had reports of individuals who have basically had individuals get into their email, get into their MLS access. You have to have security protocols in place, because if somebody does that plus uses AI to somehow impersonate you, it's potentially game over at that point. They're putting listings up, and you could potentially have liability in that case, because if you didn't take proper measures to protect your tools of your trade, that could potentially lead to liability back to you. So just a couple of tips. I think all brokerages should consider having an AI usage policy. Individually, I think you really want to review AI-generated content for accuracy. You want to protect personal, financial, and confidential information. Don't use AI to create content you wish to copyright. If it's something that, whether it's confidential, personal, something that, photos that you want to hold the copyright to, the minute you put it into something like ChatGPT, it really puts it into the public domain. I've seen attorneys say that they've seen and heard of agreements they put in. They'll put it into AI to ask it to review an agreement, right? And that the terms of that agreement can then be kind of spit out to someone else looking for, an agreement on the same subject. So you really, really need to be careful with that. Never use it for contracts or legal advice. I can tell you, I've experimented with it. It's not accurate. So not only could you potentially be involved in the unauthorized practice of law, but you could be giving bad information out. So make sure you're following those risk reduction tips. You want to make proper disclosures when using AI generated or enhanced images. Provide both the original and altered images. If you're going to enhance photos in any way, try to have side by side or linked. Just you want to give access to both. And I would strongly encourage you, anytime you're enhancing any kind of photos, make sure that it's captioned as such. You want to put AI generated, visually staged, digitally enhanced. You want to give the consumer a transparent view of the property. Certainly, you never want to misrepresent the core condition of the property. Don't use it to hide defects. Don't use it to alter things structurally. The key, and I was on a video meeting with Department of State earlier this week, it's ensuring transparency. They said we don't have an AI policy, but we look at transparency. We don't want buyers being misled into expecting something drastically different when they see a property in person. And that's going to lead to complaints, and that could lead to potential liability. All right, I'm going to move a little quicker now just to cover a couple other topics. I just want to make you quickly aware of some changes that were made to the Code of Ethics, or that are being made. They were approved last month, November, and they are going to go into effect in January. They're not major, but they kind of address some important issues, I think, that everybody should be aware of. The first one was Article 7 was amended. And basically, it says that if you're going to get compensation from more than one party, you only need to make sure that you've disclosed and approved that, have the approval of your client. You don't need they clarified, it's not that you need approval of both parties. It just makes clear, and the reason for this change, it goes back to one of the first questions that we had today, right? There's no obligation for the buyer broker to disclose the contents of their agreement to the seller or their broker. So if a buyer broker has an agreement that says, I'm going to get paid compensation by my buyer, and I'm now asking the seller to cover all or a portion of that, there's no obligation for that buyer broker to provide the seller or inform the seller what they're being paid by the buyer. So that was why Article 7 was amended. It's, again, not a big change, but it was made for that very reason, to say that buyer brokers, you do not have to give your agreement to the listing broker. This one, Standard Practice 3.4, was deleted. I'm not really going to get into it too much because it was never applicable in New York. So it had to do with disclosure of variable rate commissions. New York State felt it intruded on private negotiations between the parties. So this was something that New York State had already said was not valid in New York, and it was effectively deleted here. The last thing was just in Article 17, which deals with arbitration, right? It was amended to make clear that if you are a buyer broker and you're bringing in arbitration, you cannot collect more than the amount you've agreed to with your buyer in your buyer representation agreement. This is a change that was made to make Article 17 more in line with the NAR settlement. Remember that under the NAR settlement, what needs to be, you have to have that written agreement with a buyer before touring a home, and there are certain things that need to be in it. You have to disclose the amount or rate of compensation. It has to be objectively ascertainable, not open-ended. You have to have something that's discernible. You can't say, I'm going to get paid whatever the seller is offering or will pay. But it also needs to state, and this is a requirement, whatever you've agreed to with that buyer, you can't get any more from anyone else. That is the limit. That is the maximum compensation you can receive from any source. So that is why Article 17 was amended to say that Even in arbitration, the maximum you could receive as a buyer broker would be whatever you've agreed to in that written agreement with your buyer. And then just lastly, remember under that settlement, your written agreement with the buyer, you need to conspicuously state that broker fees and commissions are fully negotiable and not set by law. Another topic, I used to cover this a couple of years ago, and it's something that someone asked me to kind of readdress because they've seen a little bit more of it in connection with some of their listings. And I asked around to a couple other agents who said the same thing. I don't know if it's because we're still at a pretty low inventory. Maybe this is a practice that buyers who are just trying to hope to get their offer accepted feel that they need to engage in. But it's not something that I recommend, and that's the practice of buyer love letters. So what's the love letter? It's the buyer saying, "Hey, I want to write a letter to the seller because I want them to take my offer. I want to stick out. I want to give them some reason to pick me. I want to show that I have a personal connection to them. I think I'm a lot like them, so I want them to know that. I want to make them feel like they should prefer me over someone else." I think you can sense where I'm going here. That can create some problems. It's not illegal, so I just want to make clear. I say per se illegal, meaning it's not automatically illegal. So the practice of sending love letters from a buyer, no one's going to say, "Hey, that in and of itself violated the law," but they're highly discouraged because they can lead to fair housing violations, right? Especially if the buyer is starting to say things about themselves to explain who we are or why we think we're like you, Mr. or Mrs. Seller. That puts the seller in a position of potentially indicating a preference for a particular type of person, a type of protected class. So could be as innocuous as somebody saying, "Hey, we're the Smith family," or they get into religion, right? This time of year. They could say, "Hey, this house is ideal, especially the kosher kitchen," or we really see our family enjoying Christmas around the living room fireplace, just like you have your living room set up. You can see how this can create problems. It's not like just saying we love the fireplace. Nothing wrong with that, right? But you don't know what they're writing in the letter, and there's really a risk that people can. I think it's just potentially human nature. Oops, went a little back, but the big issue is that last point, right? If a seller says, "I'm going to sell or not sell to a particular buyer based on things that were in that letter," that could open up a fair housing complaint. Paula, right? Just mentioning family is a protected class, and I don't think I'm not saying that there's anything a buyer's doing. It's not nefarious. It's not like they're intentionally trying to break the law or cause a fair housing violation, but they could put a seller in that situation. And it's not something that the seller should be considering. The seller should be considering what is the best offer here. Not, who do I want to help? Who do I want to see in this house? Those things create problems when it comes to fair housing. So what do you do? I would never suggest a love letter. Certainly never suggest a letter that identifies a protected class. Remember, it's illegal to refuse to sell or rent to a prospective buyer or tenant based on a protected class. So if you've given the seller a reason to do that, you're kind of halfway to a fair housing violation. And if you facilitated it, guess who's going to be part of that complaint? You. So I just stay away from the letters, right? If a seller gets the letter, you should explain the implications and say, I don't think you should open or accept the letter. If you represent a buyer who wants to send a love letter, I would advise them, don't do it. Document your advice. And I say document in both of these instances, put it in writing, put it in an email, put it in a text message. If the buyer says, "I want to do it," I would not read. I wouldn't be involved in the acceptance or delivery of the letter. Just stay out of it and document it. Say, look, I understand you want to submit a letter to the sellers. It's not something that I would recommend doing, and I am not going to be a part of that practice. It is just something that I think puts you in jeopardy. So don't be involved in delivery. If they need to do it or want to do it, make them do it themselves. And sellers can not to instruct the broker, say, I don't want you to accept any offers with personal letters. I think that's good practice for sellers. What do you do worst case? Let's just say, you sit down with the seller, your listing broker, and the seller's like, hey, the buyers sent me this letter explaining how great a family they are and that they're such and such religion or nationality, and I would really prefer that. What do you do? I think you have to, in that instance, you need to back out. You don't want to be part of that. I mean, if that ever comes to light and a seller makes a determination on that basis, it puts you in a lot of jeopardy. And my recommendation would be withdraw. Commissions are not worth the potential of a fair housing violation. Certainly, if that instance comes up and you're a salesperson, speak to your broker, speak to your counsel. But I do think that's why the whole practice to me is just a potential minefield. And I would recommend not stepping into it to begin with, because you don't want to put yourself in this very situation that is up here on the screen. All right. Another topic that I do cover just about every legal update. So some of you may say, like, Patrick, I've heard this. I'm going to say the message is still not getting across, and I'll explain why in a minute. But I am going to continue to cover this topic in pretty much every legal update until we really see a drastic reduction in the number of violations and complaints related to lawful source of income, because it continues to be a problem. So lawful source of income. A housing provider, this usually comes up in the context of rentals, right? Apartment complex, apartment owner can ask about income. They could ask about your source of income. They could ask you for documentation in order to determine how you're going to pay for the apartment. Asking about income, not an issue. That's not discrimination. The discrimination is if they don't accept all sources the same, right? They have to treat every source of income equally. They can't say, I prefer tenant A because they get their income from a job, and I like that better than tenant B who gets income from Social Security or child support or alimony, whatever it might be, housing choice vouchers. That's the big one. They have to look at all sources and treat them equally. It's no different than a landlord who would say, I like this color tenant better than that color tenant, or this religion better than that religion, or I like tenants without children better than tenants with children. It's discrimination to say, I like tenants with jobs better than those who have Social Security or public assistance. That I hope gets people to understand what lawful source of income discrimination. So why am I still talking about this? Because it's still a subject that is the source of testing and the source of violations. Look, these are major in the last year. Just all of these are just the reported ones. Significant violations. And I don't want to see anyone in our industry in these reports having to pay a fine and potentially having to lose their license because they committed an act of discrimination. And I will tell you that Department of State, they've put out, they understand that there's been a lot of education on this. They're done treating this as like a minor violation. If you violate and discriminate based on source of income, they will look to suspend or revoke your license, period. That is the way that they're looking at this. They take it seriously. And look, we just had a case this month that was reported by the New York State Division of Human Rights. So it's still happening. Here's some examples of what source of income discrimination does look like. It's hey, I don't work with voucher holders, or this landlord won't accept vouchers, or I have to find out if the landlord accepts vouchers. If a landlord's working with you as a real estate licensee, you have a duty under the law to work with everyone, regardless of whether they have a voucher or not. So you can't, if you say I need to find out from the landlord or this landlord doesn't accept, that you've broken the law. You have to, landlords have to accept vouchers. So I mentioned the most recent case, and this is why I was like considering maybe I can move on from this. And I said, no, you know what? I just looked just this month. New York State Division of Human Rights issued a press release that said we found a brokerage. We had to settle the brokerage $40,000. They had testers go out. It was through the Fair Housing Justice Center. Very easy to test too, right? They get two people. They could just make phone calls. One says, I'm calling about this apartment. I have a job. And someone calls about the same apartment and says, I have a voucher. Voucher covers the rent. So no issue. You got two tenants who can pay the rent, period. Well, there were disparities, right? They were not treated the same way. The agents ghosted. They just didn't respond. They heard somebody has a voucher. They didn't call them back, or they just ghosted them. That's a violation right there. They even had some landlords say, hey, vouchers are not accepted. Again, violation. So unfortunately, it's still happening out there. And it is so easy to test. That's why I really want to make sure that you are aware of this issue, and that you take the steps to avoid lawful source of income discrimination. And it's really easy. Just don't turn away a prospect because they receive any sort of financial assistance. You're going to tell prospects about all the vacancies that meet their needs. If someone calls and says a voucher and you say you can't work with them, it's the same as someone saying, I'm this religion, I'm this race, and you saying, I'm not going to work with you. It's discrimination. It's treated exactly the same way. So how do you avoid it? You treat anyone with a voucher the same way you would any other prospective tenant. You ask them the same questions, right? What area are you looking in? How many bedrooms are you looking for? What's your price range? And you're going to show them all the same apartments you would any other prospective tenant. Don't complicate this. It's very easy. Just have a system in place where you treat every tenant, regardless of what they look like, where their income comes from, you treat them all the same way. Keep it simple, not difficult to do, right? Lastly, what if you come into this situation where the owner says, hey, I'm not going to accept anybody with a voucher? Well, you know what? Very easy. Again, simple. Don't work with them. It's not worth working. You're going to break the law, and you're probably going to get reported. Just don't work with them. You have a great, in what you do, you actually have a lot of power, right? I said this when I was in private practice as an attorney. You can refuse to work with people. Don't forget that. And sometimes the best decision to make is not to work with someone. If you get the sense that somebody is going to be not only break the law, but be difficult on something like this or anything, don't work with them. It's going to lead to aggravation. You're much better off focusing your time on a different prospect who is going to follow the law and ultimately lead to a successful transaction. Don't be afraid to say no to clients and walk away from them. Yeah, Laura's right. Autonomy is a beautiful thing. Remember, you have autonomy. You don't have to take a difficult client on, and you certainly should never take a client on who is not going to follow the law, because they are going to lead to a licensing issue. Lastly, I said lastly on the last slide, but I did have one more on this subject I just want to cover because this question comes up a lot. And this is all on our website too. If you go to lirealtor.com and you search lawful source of income, or you go to Home for All of Us, which is another website we created, we have a lot of information on lawful source of income, but this comes up a lot. So the question is, can the landlord require a credit check or credit scores for voucher holders? So first, landlords can advertise that they have a minimum credit score, minimum income. Fine. They have that in the advertisement. But if the voucher covers 100% of the rent, the landlord can't apply those requirements to that tenant. Why? They've got a guarantee from the government or whatever programs providing that subsidy, that they can pay the rent. There's no need to verify anything further. And doing so would actually automatically disqualify them. So it's kind of a backdoor way for a landlord to say never going to accept vouchers. So if 100% of the rent is covered, landlord cannot require a credit check or reject a tenant based on credit history. If the tenant's paying a portion of the rent, credit can or may be considered on a case-by-case basis. But landlords need to be cautioned that requiring a minimum credit score, it could still violate the law if they're using that in a way to disqualify anybody who has a voucher. And I will say almost every voucher program has already vetted the tenant to know they have the means to pay the portion of their rent. They've done the background work. So I think the best thing to do in those instances is check with the program, see what they've done, what information they can provide to show that the tenant can pay whatever it might be, the 10, 20% of the rent that the program will not cover. So credit scores and history, again, they might not be a valid indicator. The voucher holders often are going to have little or no credit. That's why they're getting the voucher in the first place, right? So using a score is sort of that backdoor way of excluding them. So landlords do need to be careful in that situation. But number one rule up top, and most of the programs do cover 100% of the rent. Not everyone, and it's obviously case by case situation, but landlords do need to be very careful when it comes to credit scores and income requirements for voucher holders. All right, that concludes the class.